A very warm welcome to all of you for this session. Today we will be discussing about the myths and facts related to the Bharatiya Nyaya Sanhita 2023. We know whenever a new thing comes, there is certain apprehension. When the computers and laptops came, we were thinking that are they going to replace us? Then with the AI technology also we feel that are the AI technology going to replace in the field of medicine or in the fields of IT, in the field of education, in the field of health infrastructure. So we know every time whenever we come up with a new technology or a new law or any new change, that has lot of apprehensions and lot of thought process in our mindset, because we are used to a particular lifestyle, and when I say that you have to divert or you have to add on to your lifestyle, maybe you will be confused, you will be thinking that should I change or should I not change. So the Indian Penal Code 1860 is being replaced by the Bharatiya Nyaya Sanhita 2023 and is applicable from July 1st. So we need to know about this law. Before knowing about this law, it is very important that the myths and which are going in the media, on the social media platforms, that needs to be addressed. So all the learners and all the viewers and listeners of this session, we will be talking about few myths about the Bharatiya Nyaya Sanhita 2023, and then we will be also discussing about the facts. So let us see this PowerPoint presentation. The first myth is that the new criminal law threatens individual freedom and aim to establish a police state. We all know that we are living in the 5th generation of human rights. So in the first generation of human rights, we were only talking about the political rights and civil rights. In the second generation of human rights, we were talking about economic and social rights. Then in the third generation of human rights, we were talking about the group rights. In the fourth generation of human rights, we were talking about, generational rights and futuristic rights. And in the 5th generation of human rights, we are talking about linkages between, artificial intelligence, linkages between the social and the holistic development of a personality. And how can you feel that in the 5th generation of human rights, your fundamental freedoms, will be curtailed, and India from a police state, it became welfare state, and then from a welfare state, it became, individual centric state. And now can we think that it can again go back to a police state? No. The answer to this myth is no, because we have constitutional law which says, the Constitution of India talks about fundamental rights, it talks about directive principles, it talks about the fundamental duties chapter, and the preamble has certain goals which we have to adhere to. So this is a myth that the new criminal law will threaten individual freedoms which are guaranteed under the Constitution of India, guaranteed under the Protection of Human Rights Act, and guaranteed under different legislations. They are enabling legislations for the vulnerable group. So it cannot violate the provisions of the existing legislations which are for the benefit of the mankind. Then the fact is, it is a safeguard against misuse. The new laws incorporate safeguards to prevent misuse of power, emphasizing accountability and transparency in law enforcement actions, instilling confidence in the justice system. Now we are talking about, audio video recordings. Now we are talking about in-camera proceedings. Now we are talking about technology advancement in evidence. So how can any new law restrict your individual freedoms or curtail your individual freedoms? It will improve day by day. As a system we are improving, because with the advent of technology, with transparency and accountability on the part of the public servants, on the part of the government, now the system has become such that it is more transparent, and you are able to go and see on any website the details related to a particular organization or a particular setup. All the forms are online. So we are moving towards a digital India. So when I talk about digital India, this, myth that, it will curtail my individual freedom is not true, because as I remember when Aadhaar had come, we had apprehensions that it will be a violation of your right. But it is advancing towards a social and, holistic environment wherein you grow. You grow economically, you grow socially, culturally, and then you have all avenues to prosper. Then, as I discussed transparency and accountability, we will also talk about, the police accountability and safeguarding individual rights. Because, all the process, even the FIR can be done online. So EFIR facility is there. Then zero FIR facility is there, which we will discuss after some time. So that the system is more transparent now. The system has to be accountable now. So the myth is wrong. Then, we have accessibility and convenience. As I just said that we can file EFIR, so you don't need to go to the police station physically and register your FIR. You can just file EFIR and all the details are there recorded and will be also there as evidence. So whenever you lodge a complaint on 112, then it is recorded. So they have to take action and then they have to report whatever action has been initiated on your complaint. So it is that we are facilitating the system, is facilitating us. We don't have to move. So physical boundaries, physical spaces, our physical limitations have been reduced. Now we can sit in our house and file an FIR. Then, you can also, preserve your personal liberty, because, unnecessary arrest will not be done. The denial of bail only on the ground of extended police custody beyond first 15 days is not allowed. So this is also a very important provision. So, your personal liberty is ensured by the Bharatiya Nyaya Sanhita 2023. Then jurisdictional flexibility is also there. When I talk about jurisdictional flexibility, I have to refer to the zero FIR, which I just said, that it eliminates jurisdictional constraints, enabling individuals to file complaint at any police station, thereby expediting the legal process and improving citizen friendliness. It is very important, the crime has happened at one place, I stay at some other place. So, you cannot limit me from filing a FIR at the nearest police station. So I can file EFIR. So this zero FIR gives me the benefit of filing FIR at my nearest location or at my place of residence or at the place where the offense has been committed. So you will not say, oh, you are coming at a wrong jurisdiction. You have to go to this thana. You cannot say that, oh, this magistrate will not look at your case. So sorry, you cannot file a case. I can file a case and then the police station will transfer my case to the concerned police station. So it is not my responsibility because I am the victim. So it is not my responsibility that I go from thana to see my jurisdiction and to see whether I am able to file a complaint there or file FIR there. I can sit in my home and file EFIR, and I can file zero FIR where my case will be transferred to the related police station. So there is a mechanism of oversight mechanism and accountability which we have discussed, that there are strict oversight mechanisms including mandatory recording of arrest and of evidence collection, act as preventive measures against potential police excesses, ensuring adherence to legal procedures and protection of citizens. So it is also very important that whenever, there are some rights of the accused and some rights of the people who have been victimized. So the witness will be protected, the victim will be protected, the accused will also be protected till he is found or she is found guilty and convicted by the law. So there is an accountability procedure. The police has to record all the proceedings and the evidence also has to be technology enabled. So when we have evidence technology enabled, then the chances of convictions are high, because we are using mobile technology to record evidences, and the evidence is valid under the Indian Sakshi Adhiniyam 2023. And we have so much, your forensic can be helped by a lot of technological advancement with this AI tools, because everywhere we feel, that we have inbuilt AI technologies in the homes. We are using Shri, and we are using, different apps wherein, we interact with them, like, and we say, Alexa, do this, Alexa, do that. So they are basically recording, and that evidence can be a big, evidence when it is produced in the court of law. So every AI app, or the cameras, or the mobile phones are becoming a good piece of evidence. Even the laptops and the computers are becoming a good piece of evidence. So whenever we are using the technology, it is also benefiting us, and we have certain things, do's and don'ts. Then protection of fundamental rights is also there, that the new law protects your fundamental rights, because it is transparent, it is accountability of the service provider is there, accountability of the stakeholders is there, and it protects your fundamental rights, including the right of free speech and to assemble peacefully, and arbitrary suspension is curtailed. But whenever I talk about fundamental rights, we have to understand that fundamental rights are not absolute. So whenever you think that you can speak anything, no. Every right has a reasonable restriction, and then you have fundamental duties under Article 51. So you have 251A. So you have to refer to those duties and take everything not as a stride, but as a responsible citizen of this country. Then there is a second myth. First is that, our fundamental freedoms are curtailed. The second myth is that it is the repacking of existing draconian provisions. Whatever draconian provisions we had then, we are referring that the Indian Penal Code had draconian provisions, and now, it is just that we have repacked the same provisions. So no, this statement is wrong. The Indian Penal Code also did not have this draconian provisions. Neither the Bharatiya Nyaya Sanhita has draconian provisions. So, the law talks about concept of justice, which is enumerated under the Constitution of India. And, the introduction of citizen-centric, victim-centric, sensitive to offences against women and children, because we have a specific chapter now of offences related to women and children, chapter 5. So it is very important that we understand that, it is a victim-centric law, it is a citizen-centric law, it is also an accused-centric law, and it focuses on the offences against women and children, and it also introduces new offences such as Deshdroh, terrorist acts, mob lynching, organized crimes, petty organized crimes, snatching, etc. And I have just discussed that, in the organized crime, they have given a very wide definition of organized crime. So a lot of things are included in the term organized crime, which were not there in the earlier Indian Penal Code, including beggary. So now we have and trafficking. So you have to understand that, mob lynching. So all these provisions are there. So it is more realistic. It is more, victim-centric. It is more, citizen-centric. It is more accused-centric, because every accused has a right under the Constitution of India, under different laws. So, you cannot torture, you cannot abuse, and you cannot play with the rights of the people of India. So whenever you are using technology, the rights of the people of India will be protected. So it is more user-friendly as compared to the other law, because the earlier law was not talking about technology and AI, but the new law incorporates all these new advancements. It incorporates all the new offences. It also talks about, having a very victim-centric, period, where we were talking about compensation as a relief. And now we are talking about compensation as a matter of right, wherein you don't have to pay compensation to that person, which is very meager or a very minimum amount. But compensation will be on the basis of the suffering which that person or the victim has suffered. So for medical expenditure, for psychological expenditure, for rehabilitation, reintegration, whatever, money is required will be paid by the accused. So it is a very welcome legislation. Then the provision of destroy, you cannot burn the you cannot set fire the railways, the trains, the buses, public, property. So you have to have certain checks and balances in the new law, and this Bharatiya Nyaya Sanhita has it. Then the sedition law, in the IPC has been removed by the Bharatiya Nyaya Sanhita. The repeal of section 124A is a positive step adhering concerns of misuse against dissenters and critiques of the government. So now you have to have a check and balance format wherein, everything is not sedition. So we have repealed this section of sedition which was earlier there in the Indian Penal Code, and we have a positive law. Then we have gender neutral provisions. So sometimes, we used to think that these offenses can only be committed against women and, girls. No. Now we have gender neutral terms, which includes women, girls, and, the third generation rights are also there. The fifth generation rights are also there. So we have a broader interpretation of the term person. We have a broader interpretation of the term, gender. Then we are also specifying, that whenever we are talking about LGBT and Q, we are also addressing these issues there in the law, in the new law. So we are addressing all these issues in the new law so that everybody feels that the new law is for them and is framed in a way that they will benefit out of it. Then mental health terminology, which was very stigmatic because, when you call somebody lunatic or idiot or insane, then it has a different meaning. And when you call unsound mind or, intellectual disability, that has a very sensitive and positive approach. So the new terms are used for mental health. Then time-bound prosecution for civil servants have been there. So providing time-bound approval for prosecuting erring civil servants ensures a more efficient legal process, fostering accountability and preventing undue delays in addressing allegations of misconduct. So this is also a very positive step. Then community service for criminal defamation. It is also very important, when you move in the community and you do community service, because every religion promotes community service. So you are reintegrating that person in the community, and you are bringing a sense of responsibility and a sense of ownership towards the community. So people, who are staying in a nuclear family or who have nobody to take care, or who are staying alone and are deviated, can, participate in the community service and, reintegrate in the society. So this is as per the modern approach of justice, inclusive society, a holistic society, because you are including even the offenders, the convicted people in the mainstream by community service, and by interacting with the community, they also feel, motivated. And sometimes, you commit a crime because of your situation, then maybe out of the community service you learn something, or by vocational service you learn something, you develop a skill, and you are out of the vicious circle of poverty. So the other myth is the extension of police custody from 15 to 90 days in the new criminal laws is a shocking provision that will enable police torture, So the myth is that when you are there for 90 days in the custody, it will, be a violation of your human rights, your legal rights, as the police will torture you. No. Then section 187 of the Bharatiya Nyaya Sanhita BNSS lays down the procedure when investigation is not completed within 24 hours. The period of police custody is restricted to 15 days, just like before. Now, under BNSS, police custody may be taken in two parts, in whole within a period of 40 to 60 days out of total period of 60 to 90 days as applicable. And every case to case the magistrate will decide, and the judge will take due cognizance of the fact that there is no violation of the person who has been arrested. So all his rights will be protected as per the guidelines given by different judges in the judgments. Similarly, we have provisions where the magistrate will decide whether it is needed or not needed. The court's discretion in granting police custody is retained as earlier. Police custody beyond the first 15 days shall not be an impediment to grant bail to the accused if he is otherwise eligible for bail. So, you can ask for bail, and if you are eligible for bail, then definitely you will get a bail. Then another myth is regarding sedition. Sedition is gone, but this provision of Deshdroh, in the Bharatiya Nyaya Sanhita is a very wrongful thing which they have introduced. No, this is just a myth. The fact is that the sedition provision has been removed, and the law talks about concept of justice, which is embedded in the Constitution of India to improve criminal justice system of the country. So, whenever we talk about the provisions of Deshdroh, the term has been defined, and the judges will take due cognizance while deciding whether the case is of Deshdroh or the case is just by, you are just saying something, or freedom of expression. So there is a limit. I just told you that every fundamental right has a reasonable restriction. So you cannot just say anything against the state, and then you have a fundamental duty also. Then this Deshdroh has been defined, as I just told you, actions endangering the sovereignty, unity and integrity of the country is very important. So, you have to ensure that you do not speak something which is endangering the sovereignty of the country, the unity and integrity of the country. If that is not, then this is not an offense of Deshdroh. Then, unlike section 124A, section 152 goes beyond criminalizing expression causing hatred towards the government. It punishes acts such as armed rebellion, subversive activities, separatist activities, thus providing a comprehensive approach to protect the nation's integrity. So, whenever you are forming groups and where, you are talking about, having a conflict regime, or, overthrowing the government, or an armed rebellion, or an unrest situation, or a riot situation, then that can be controlled under the provisions of Deshdroh. Because something which is, affecting your sovereignty, your integrity, then, or, the means is violating the basic structure of the Constitution, then definitely the state and the government has the responsibility to protect its citizens. So, we have inclusion safeguards for freedom of speech and expression by distinguishing between deliberate threats to the nation and genuine expression of opinion. So, these two things, will be taken into consideration while deciding whether this is an offense of Deshdroh or not. So, it is not that every statement is against the country and this is an offense of Deshdroh. No, if I express my opinion, it is okay. But if I burn, or if I make illegal group and do illegal activities to overpower the government or to overthrow the government, then this is an act of Deshdroh. Then another myth is that harsh punishment of 10 years of imprisonment with 10 lakh fine to hit and run cases under Bharatiya Nyaya Sanhita. we had seen that the truck drivers and the drivers across India were thinking that, for hit and run cases, there is a harsh punishment with 10 years of imprisonment and 10 lakh rupees of fine. So the way it has been interpreted is wrong, because, this 10 years of imprisonment is for people who, have not followed the road safety guidelines, who have, have a malified intention, or, who have just run away from this situation. If you hit a person and you take that person to the hospital, then you will be safeguarded. But if you just hit a person, or you just consume alcohol and then you just hit sleeping people on the road, so what people are sleeping on the roads, and then you just hit them, you just crush them, then you will not be safeguarded. But yes, if by accident somebody is hit and then you take due care and caution to call the police to take that person immediately to the nearest hospital to, help that person in surviving, then that will be a different case. To enhance road safety and justice for victims, the new law introduces identified penalties to curb the rising incident of hit and run accidents under section 1061 and 1062 of the Bharatiya Nyaya Sanhita. The law provides gradation of punishment in hit and run cases. As I just told you that, the amount of fine being 10 lakh is completely false. The enhanced punishment of 10 years is for those who escape without reporting the hit and run case. The offence is still bailable, triable by the magistrate court under section 1061. But, the Ministry of Home Affairs, after, a serious, concern raised by the truck drivers in the country, has, stopped this provision from being implemented. And they have discussed with the All India Motor Transport Congress, and, the decision to invoke section 106 clause 2 will only be taken after consultation with All India Motor Transport Congress. So till now this provision is not implemented. Even in July this provision will not be implemented. It will only be implemented after having discussion with the India Motor Transport Congress. So, we have lot of myths and, things about the Bharatiya Nyaya Sanhita 2023, but we have to know about this, because without making any statement, we are educated people, and even if we are not educated, we have to understand that the law is framed for the benefit of the citizens. It is for, in the fifth generation of human rights, it is going to uphold your dignity rights. It is going to, uphold the provisions of the Constitution of India and your legal rights and the statutory rights. So thank you all for this session. Have a great day.